Check, 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 check. Here. Let me- Let's see. Check, 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 check. Yep.
Okay, welcome to the October training. Wow, that is loud. October training, lobbyist training. I'm Tom Albritton. I'm the director of the Alabama Ethics Commission. This will take about an hour. Some of you may have sat through this before, but this is just a general overview. It is only meant to touch on the major issues that may affect you as a lobbyist, your basic requirements, the basic prohibitions. If you have any questions, if you're attending by webinar, be sure to text those questions to this number. I will probably deal with those in bulk, probably toward the end of this training session, but feel free to text to those. You can also call if there are technical difficulties that you're having on your end, and we'll try to address those to the office as best as we can. Remember that everything that we say here is just general guidance. It doesn't give you any kind of legal protection. And what we're telling you here is the floor, not the ceiling. You are certainly permitted to go above and beyond what the requirements are here in an effort to over-comply with the Ethics Act. In truth, I don't think you can over-comply with it. But just remember that this is the floor, this is not the ceiling. You having trouble viewing these slides? Is this a little bit better? Now it's blocking barking ears now. Okay. Well, I can't make everybody happy, but I'll do what I can. Just remember that the environment in which you are going to be working has been colored by some scandals that have happened in the state over the last few years. And every one of these is more complex than the slide I'm about to show you will imply. But nonetheless, the average citizen has viewed these, and they have viewed these over the last couple of years, and it's just kind of created a general perception in Alabama regarding the climate of compliance here or the lack thereof. And Alabama is viewed in many places by many people as a corrupt place. From a political standpoint. Let me be the first one to say that we have a lot of prosecutions in this state, and we have a lot of enforcement in this state. There's a lot that's been written about that. So the fact that there's been a lot written about this, in my view, is not evidence that we are a corrupt state. What it is it's evidence that we have active enforcement going on in this state, whereas in a lot of states you don't have that. So I think that it's a good sign, but I also will tell you that based on the statistics we see in our office, the overwhelming majority of public servants, the overwhelming majority of lobbyists are doing it correctly and are not violating the law. So these are just the few bad apples that are spoiling the bunch. However, it does go into the common perception that is relevant to you because the people who are going to complain about it are going to be viewing you through this prism, be viewing you through this lens and your actions through this in the context in which these events have occurred. We've got the former governor whose case was news story a year or so ago. We've got the former speaker's trial. That conviction was affirmed by the Court of Criminal Appeals recently. The former speaker is not through with all of his appeals, but he's pretty close to the end of that. The Court of Criminal Appeals affirmed 11 of 12 counts that the jury returned a guilty verdict on. And prosecutors, and I think rightfully so, have taken that as evidence that the Ethics Act is working in Alabama in spite of criticisms that certain people may have of it. We got Mickey Hammond, guilty of mail fraud up in Birmingham. We got Oliver Robinson. That's certainly not news to anybody who has been around for the last year or so. We've, as a commission, have referred cases against county officials too, including sheriffs in Barber County and also in Limestone County, Alabama. And this was done at our most recent meeting. We've got the Birmingham Waterworks Board. So you've got it at all levels. You've got federal authorities who are handling these. You've got state authorities who are handling this at the state level of government. You've got county level violations, and you've got city level violations. Former county administrator sentenced to 20 years for stealing $750,000 through her position. All of this has occurred within the last couple of years. I'm not going back decades to find these. I mean, these are the most recent things, and there are slides that I have not put up. This just gives you clear evidence of how frequently these kind of stories are being reported on the online news services. You've got this conviction that was returned fairly recently this past summer. The important thing about this verdict is that for the first time, at least that I'm aware of, those who are similarly situated to the position you sit in have been held accountable under under federal statutes that mirror to the same extent a lot of the prohibitions we're talking about here. Let me also use this as an opportunity to say that the law firm that's mentioned here is a reputable firm, is an ethical firm, and simply having one member of that firm who a jury found had violated certain laws affects everyone in the organization. This is the point to be made, that you do not operate in an isolated fashion. Your actions affect those you are in business with who are complying with the law. And that's a very, very unfortunate and sad result for everyone who has found themselves the subject of these stories that I just mentioned. We have a website. That should be the place you go to for information. If you've got questions about who to contact, you've got questions about requirements that may be placed on you, or if you want to know how to get up with Vicki Manning, who is your point of contact if you've got lobbying questions. So Vicki, I need you to stand within the square of trust here. So everybody online can see, this is Vicki. If you've got questions about your quarterly filings, you've got questions about how you amend filings, this is the person you talk to. This will be that smiling face with the happy voice on the end of the phone that you talk to, and she also will respond to your emails. And so feel free to contact her, but that should be who you contact. And you can get her information from our website. The other thing you should know about our website is that all of your quarterly filings are viewable from our website directly by the public. So when you file something, if you file something that is incorrect, or if you file something that is fraudulent, the public will be able to see that. They don't have to go through us to get it. They can actually search under your name, they can search under the principal's name, and they can find your disclosures. So that would be available through our website too. Our commission is actually made up of 5 individuals who are appointed by the governor, lieutenant governor, and speaker of the House to serve staggered 5-year terms. Our chair is Jerry Fielding, retired circuit judge from Sylacauga. Butch Ellis is our vice chair. He's a lawyer from Columbiana, Alabama. We've got Charles Price, who is a retired circuit judge from Montgomery. We've got Beverly Brady, who is a lawyer in Auburn, Alabama. We got John Plunk, who is a lawyer in Athens, Alabama. That is an extremely old picture of John Plunk. He is an older individual than this picture indicates. However, he's very proud of that picture, and we're proud to have him on the commission. We've got 5 lawyers, including 2 retired circuit judges, on the commission. That is a bit of a new development for the commission. However, you've got 5 good people who are looking at these issues. They are the ones who make the official decisions. They're the ones who approve our advisory opinions. If you ask us to interpret the act in a certain way through an opinion, it's these 5 individuals who will be ultimately deciding the answer to those questions. They are also the ones who decide whether there's probable cause for violations of our act. If you have questions about our act, you can ask for us to answer that through an advisory opinion or an informal opinion, but we can answer the question for you. Several of you have taken advantage of the informal opinion process, so you know how that works. For those of you who haven't, let me tell you that all you've got to do is send us an email. We will answer the question for you, but you've got to put it to us in writing. There's an administrative rule that requires that it be in writing. That is a good thing for you because it gives you something you can hold in your hand. It also is good for us. It holds us accountable, but it makes sure that we have communicated in a way that is clear and that we have answered the questions that you have asked. Our formal advisory opinion is the only document that the code allows us to give, which gives you any kind of protection from prosecution, but it does do that. A formal advisory opinion that is voted on by our commission, as they all are, gives you protection from prosecution within the confines of that document. So if you've asked the question, you've given us the right set of facts, you haven't misrepresented anything to us, and you rely on that document within its 4 corners, then you are protected from prosecution for that. On our informal opinions, we have a process we go through where we assign it to an attorney, and it goes through a review process, a couple of levels of review. We try to get those turned around in about 14 days, but that's really the turnaround that you're looking for. Every now and then we will have somebody who needs a quick answer. Because you've got something coming up quickly, we will do our best to answer that. We're generally able to give you an answer fairly quickly. We can't call you and give you the answer, but we can get a quick email to you and then call you and tell you that it's in there and tell you what it says. So if you've got questions, don't hesitate about asking them, even if it's something that's coming up quickly. We just ask you to ask it well ahead of time if you've got a question about that. Our formal advisory opinions are voted on at our meetings. Our commissioners have their meetings every 60 days. So you might not be able to wait 60 days for an answer. Just to give you some perspective, we give about 700 plus informal opinions a year, and we'll give anywhere from 15 to 25 formal opinions a year. So most of the work that we're doing in answering questions is through informal opinions. Any questions about the opinion process at all? All right, on our website, there's the email that you can use to send those questions. Okay. Oh, the other thing, let me tell you about the opinion. We every now and then, people will send us questions and they'll ask us whether conduct that they have already engaged in was okay or not. And our rules don't allow us to answer the question in that way. We can only answer it prospectively. We cannot grant absolution. So don't do that. If you are concerned about certain conduct, ask it ahead of time, rather than asking if you did it right or didn't do it right. We would love to be able to answer that question for you, but we just really can't. We can't do it that way. Okay.
Not a case of better to ask for forgiveness information.
That's right.
Much
I mean,
better to ask permission to get the answer.
yeah. Yeah. I mean, yeah. Now I'll tell you this: if you have filed your quarterly disclosure and you forgot something, call Vicki and say, oops, I left this off. We will let you amend your disclosures. We want you to do that. We don't want you not to disclose. We want you to disclose. So feel free to do that. And every now and then we will have strange questions that are asked on the about disclosures, about how to disclose certain conduct or certain transactions or certain relationships even. We are pretty good about accepting amendments in the form of letters, emails, and we'll make all of that a part of your file. Our online forms can be a bit difficult in certain contexts to provide a clear answer for you. Don't let that dissuade you from answering it. Just call Vicki, call me, call Cynthia, or email us and just tell us what the problem is. And we will kind of guide you through the process of how to get a good disclosure in there. Okay, so that's the one exception on your disclosures. But if you have a transaction with a public official that violates a rule I'm about to talk about in a minute, don't call us up afterwards and say, well, I gave him $50,000. That was okay, wasn't it? That we cannot answer that question for you at that point. Okay, so any questions about any of that? Complaint process. You need to know this because all of the enforcement actions against those who come before the commission start with a complaint. It's got to be a written complaint filed with us, signed by the complainant. It's got to allege credible and verifiable information. In other words, something that, if true, would be a violation of our act, and we've got to be able to follow up and verify that that in fact occurred. But once a complaint is filed with us and it states a violation of our act, I will forward that to the general counsel, and she will, in conjunction with the chief investigator, assign it to an investigator to investigate. We've got 5 investigators. Without question, say that they're the 5 best investigators the commission has had, and I would put them up against anybody in the state of Alabama doing what we do here. 2 of them came from the Attorney General's Office Special Prosecutions Unit. The other ones are veterans in public corruption work. Our general counsel also is, and she came to us from the Jefferson County DA's office, where she prosecuted these kind of cases and others for 14 years. So you've got seasoned people who are looking at this. I'm not telling you that just to brag on my staff, although I do brag on my staff every chance I can get. But in the position we are as a probable cause board, that's who you want looking at this complaint, because they are not motivated just to find a case to prosecute. They can size these up quickly, and if there is no merit to it, they will dismiss this case or recommend dismissal early on, because that's just the answer to the question. And they do that with some frequency. And the overwhelming majority of cases filed with us are dismissed, not because we don't have time to get to them, not because they haven't been well investigated. It's because they've been thoroughly investigated, and we have concluded that there is no probable cause for a violation of the act. I also want to point out that our prosecutor and our agents, to the extent they can, have our files ready for grand jury presentation when we hand that off to an enforcement agency like the AG's office or the DA's office. We want it completed. That serves a couple of purposes. One, it verifies that we're not sending a dog. Second of all, if you have been accused of a violation, even though the complaints filed with us are confidential, in the world in which we live, information gets out publicly that something has been filed against you. Your hometown will talk about it. People in the state will talk about it. It's just very hard to keep a lid on that kind of thing. So once we refer a case, that is a public finding. And the public will know because we have to vote in a public meeting. So if we're going to do that to someone, I want to verify that there really, really is something there. So we do a deep dive on all of these investigations. And that should comfort you because it protects you from a complaint that has been filed for which there is there's no support and there's no probable cause. So any questions about the complaint process? We have 180 days to resolve every complaint filed with us. We can get a one-time extension of an additional 180 days, so the most a complaint can stay with us is 360 days. That is an enormous task for my investigators. They can handle it because they are seasoned and they're good at what they do, but they work very, very hard, and the caseload is very high. We have 500 plus cases a year, which for an agency our size is a big caseload. Every one of them will tell you that, especially when we have put a requirement on them that they do a deep investigation of them. Statute of limitations for violation of our act is 4 years. That's for intentional violations. All other violations are 2 years. The punishment for a violation, an intentional violation of our act, is to treat it as a Class B felony, which has, upon conviction, a sentence of between 2 and 20 years in prison. The former speaker was convicted under that portion of our act. Other violations of our act are punishable by up to a year and a fine of up to $6,000. Now, over the last year, the legislature gave the commission more authority to resolve cases that are minor in nature, and we can assess fines up to $6,000 for minor violations of our act, but only if the AG or the DA likewise agree that that's the proper resolution of that case. Okay, so that's how the enforcement works here. We are a probable cause board, so if we find probable cause, we refer that to an enforcement agency who then investigates further and takes whatever action they deem appropriate on it. Any questions about enforcement? This is the overall theme of the act. A public employee or official cannot use their official position to obtain personal gain for themselves or a family member or a business which they or a family member is associated. Right? That's the obligation that rests on those public officials or public employees. Now, for y'all as lobbyists, no lobbyist, subordinate of a lobbyist, or a principal shall offer or provide a thing of value to public official or public employees. All right, this gets into the kind of the heart of what you're going to be dealing with, and it involves your daily transactions with public officials. The kind of things you can do, whether you can take them out to dinner, whether there are items that they can be given that are acceptable transfers between lobbyists or the company that employs you, which is your principal, and public officials or their family members or public employees. Now, the overarching principle among all of these points is that you can't give anything to any person for the purpose of corruptly influencing official action. So think about bribery, or if you think about dropping a bag of cash on somebody's desk, or offering to do a favor for them in exchange for some official action that they would not otherwise take in the normal course of their official duties. All of that could be a corruptly influenced. Now, we don't care what you're giving, what the value of it is, because the purpose of it is to corruptly influence that public official, and that's a violation all day long, every day, as a felony. Now, with the normal transactions, there are some exceptions. Cynthia will talk a lot more about this in ways that really are more likely to come up in your daily transactions. There's a de minimis exception. I point this out because it really is a tool that you can use. There are exceptions of $25 or less for items, which is kind of meant to be a just a safety valve, a safe zone for transactions, but there is an annual cap of $50 for those items. And there are other exceptions that would pertain to educational events, widely attended events, the kind of activities that you'll find yourself in a fair amount, I think, during the session, or certainly you will hear about those. So at this time, I'm going to turn it over to our to our general counsel, Cynthia Ralston, who will talk about what those exceptions are and kind of how to navigate those.
Okay, so thing of value, let me go back for all of those out there that couldn't hear me. As Tom said before, lobbyist, subordinate of a lobbyist or a principal cannot give anything of value to a public employee or public official. So what can you give? And that lies within the exceptions of thing of value. But the definition is, you just read it on the screen even though you couldn't see me talking. And I am fouling up all the technical aspects of this today. Okay. I know you did. I didn't know it was off. But okay, so the educational function. There's an exception for an educational function, so you can provide a thing of value if it's transportation, lodging expenses, and fees for somebody's meaningful participation by a public official or public employee. And that can include spouses. All right, so it has to meet the definition of an educational function. Do we not have the educational function just defined up here? Okay, you can do that for any educational function or widely attended event. An educational function is something where it's a seminar, a conference, etc., where a lobbyist or a principal is sponsoring that, and they can provide transportation and lodging expenses for that. A widely attended event, educational functions have to be within the state of Alabama. A widely attended event does not. And you can often have an educational function that also satisfies the definition of a widely attended event. So it's a gathering, dinner, reception, or other event of mutual interest to a number of parties with varied interest, and there have to be 12 or more invitees. This is sort of an arbitrary number, but it has some history, but is not important to you, but it has to be 12 or more people. Economic development. You can provide transportation and lodging costs to facilitate their participation in an economic development function. So the hospitality exception, the hospitality has to be an integral part of the widely attended event or the educational function. You can't just go have a golfing event or a shoot or something like that. There has to be it has to be an integral part of an otherwise authorized event, a widely attended event or educational function. In the integral, and spouses can be included in that hospitality exception. Meals and food and beverage can be provided outside of those exceptions of widely attended event and educational function, but it can only be $25 for a lobbyist to provide a meal, or $100 per public employee or public official, and $150 cap a year. Okay, so if you go to dinner with somebody, you can only spend $25, whether or not that is, the dinner costs more than that or not. They have to take the rest of that cost. For a principal, it's $50 and $250 for cap for the year. For all the events that I just talked about, educational functions or widely attended events, you can get a pre-certification from us. You have to ask for the pre-certification more than 10 days beforehand to give us time to evaluate the event, and that's an administrative rule that we have, that it has to be more than 10 days. So we can certify an educational event so long as it meets all of the following criteria. It's a meeting, event, or activity organized around a formal program or agenda that has educational or informational speeches, debates, panel discussions, what you would imagine at a seminar, concerning a matter which is within the participants' official duties or other matters of public policy. So it needs to have something to do with their position, whether it's they're a public official or a public employee. I see people writing, so I'm going to wait just a minute. You want me to get out of the way? Okay. And this list can be found in, well, it's not quite laid out like this in the statute, but in the exceptions to thing of value. So a widely attended event must be all of the following: a gathering, dinner, reception, other event of mutual interest to a number of parties, reasonably expected to have more than 12 individuals, with a diversity of views or interest. This doesn't mean you have to be, accountants and landscapers and lawyers, and as long as you have, that's the reason for the number of people. If you're going to have 100 people at an event, even if they're all accountants, they're going to have a diversity of views. So, but we will be able to tell you whether or not that factor is there. It can't be purely social, no, just hunting and fishing trips. So what we're going to ask you is we are going to need a list of the public officials and public employees invited. You can't get a pre-certification unless we have that. If it's under 50 people, then your sign-in sheet's going to be required for the event. And you have to tell us how many people you expect to attend. I see writing again, so I'm waiting. What are you paying for? You need to tell us what you're gonna reimburse for them or pay for. You can do either. Actual and necessary transportation and lodging expenses. So we're gonna want to know what kind of transportation, what kind of lodging. Are you flying somebody on a small charter jet, or are they flying commercial? Waiver of registration fees and similar costs. Are they a public official, a public employee, or is it going to include also the spouse of the public official or public employee? Okay, so what are they going to be doing? It must be one of these. They must at least be a speaker or a panel participant by presenting information related to their office, or they have to perform a ceremonial function, appropriate to their office, or it's appropriate to their performance of their duties as a public official or public employee. What are you going to give them? What kind of hospitality? What kind of meal? Is it going to be, the meal that's included with everybody's registration for the conference? Or are you intending to try to take them out to a restaurant that's special and independent from the conference? We need to know that. Other food and beverages, and then you have to describe what those are. Is there going to be a hospitality suite down from 7 to 9 or whatever? As I said, it must be 10 days before. You have to ask for it 10 days before, and we will tell you that we won't pre-certify it if it's within 10 days. You don't have to have an event pre-certified, all right? Pre-certification is actually a separate exception to the thing of value definition. But if you don't have it pre-certified, some people just feel less comfortable coming to it, even if it meets all the requirements. So just try to be sure to have whomever is responsible for this ask us in plenty of time. But it also doesn't mean that your event is not permissible simply because you don't have a pre-certification. So we post all of our pre-certifications online. So everything that we do, Tom, we have an actual stamp that he stamps it with and writes, signs whether it's approved or denied, okay? And anybody and everybody can go to this website and see who has been invited to whatever lodge it is to go to your event or the principal's event. So just be mindful of that. Okay, so this is the 25 and 150, 50, 250 that I talked about earlier, that this is outside of being an educational function, widely attended event, or economic development function. This is permissible. If you just want to go to lunch with a legislator, you can pay $25 for that legislator's meal. You can only do that up to $150 for the year. And it's $50 and $250 for principals. All right, so whether or not, so we've got, all of you are lobbyists, presumably, but two of you go to lunch with a legislator and you want to talk about a similar issue or even completely separate issues. The two of you cannot each contribute $25 to that legislator's meal. It's called stacking. Principals can't do that either. So it doesn't matter if you're employed by the same principal or not, or you're talking about the same issue or not, that legislator per meal is only going to get $25 towards his meal. There's no exclusion for de minimis lobbying in our law. If you're lobbying, you are lobbying and you must register. It doesn't matter if it's for a small cause or not, or how much time it takes or not. Again, this is the advisory opinion 2011-11 that talks about that it has to have, it can't just be a recreational event. You can't just go hunting. You have to have some educational component to that. The same opinion gives, this opinion is a great one to look at if you just want a general overview of what the exceptions to thing of value are and what's permissible with principals and lobbyists. So if it's an integral part, this is where you get into the definition of integral part. So if you have a deep sea fishing or golfing or something that happens at the very beginning of the conference, that, the conference begins and you have a golf tournament, or it happens at the very end, or maybe at the end of a day of a conference, that can be considered an integral part. And we will tell you whether or not it is when you submit your pre-certification. And if it's not an integral part, you can't do it. Or you can't pay for it. You can do it. You just can't pay for it. Okay, 2018-1. This is, oftentimes you have multiple sponsors for an event. They give an amount of money, and then whoever's putting on the event takes that money and then applies it to the widely attended event or the conference. But the sponsors are required for reporting how much they contributed, and if they spent over $250 on an official or employee in a day, as required reporting in 19. So you can aggregate the costs, but you have to identify what you're paying for. So, you know, the issue is you'll have one contributor give $10,000, somebody give, $700, and everybody's just reported as the same, and that's not accurate. So if you ended up paying for hotel expenses for each room, or you're paying for the meal, there are ways that are described in this opinion, which I recommend you read if this comes up, that you can accurately report to us, but you do have to do that, and the principal has to do that. And you have to designate your sponsors as well. So this is 2018-7 is the first time we've addressed this, but with regard to executive branch lobbying, which is what has been historically called Section 1.1, where you're restricted or that it's defined as lobbying to lobby the executive branch. We identified that this is only with regards to state contracts, not local or municipal contracts. And that because the statute specifically sets out that it's just state. So if you are trying to influence the award of a contract in a county, then 1.1 does not mean that you are registering as a lobbyist. You want to do parting thoughts, or do you want me to do it?
I'll do it. Let me just come back to a few of these. This hang on. God, I'm probably the most uncoordinated person in this room. Can't use this lavalier mic. Let me tell you about the Agricola opinion. That's a good example of how we can answer a question for you. The question came up of exactly where the executive branch lobbying rule applied, and if it applied to what might be considered local executive branch folks, and 1.1 does not. It does not mean you don't have to register as a lobbyist if you're lobbying locally or at the county level. You still do. If you're lobbying their city council, if you're lobbying their commission, you still got to register. It was specifically with reference to like the mayor, or if you're trying to sell goods and services. And really all we did in that opinion was just quote the language back from 1.1. But he had a question, wanted it answered, and it got the answer. Of course, the advisory opinions are public, so they are available to anybody to look at and can provide guidance to, and they're available on our website if you're interested. Now, we can talk about educational functions, we can talk about widely attended events, unless you have some kind of context for it, they're just words. So what is an educational function? If you think about like the big conventions that large associations may have that span multiple days, and you're at a resort in Alabama like the Grand Hotel, and there are agendas every day, and you have speakers coming in, and some of the speakers will be legislators who are talking about what may have happened on their committee. That is your textbook educational function. Now, they don't all have to look exactly like that, but when we talk about those who are kind of in this daily, when we say educational function, that's generally what we're thinking of. The Business Council's annual thing, the League of Municipalities annual convention that they have. And so when they invite a legislator down there, they cover the room for them, and they cover the meals that are provided to all the recipients or all the participants and the registrants. who are attending that. That's so that they can come down, they can speak, it's consistent with their official duties, and they don't have to worry about going to prison because they took the dinner that was provided as part of the reception that everybody is participating in. Okay, that's really what that is speaking to. Widely attended event. That can take a number of different forms. During the session, your legislative receptions that may be held at state archives or may be held on the grounds of the Capitol, where every member of the legislature is invited. That's going to be your typical kind of widely attended event that you will see a lot during the legislative session. But it can be smaller groups. You can have an entire committee that's invited because it's got 14 members on it. Satisfies the definition. They're talking about bills that may be coming before that committee during the session, and it's also in conjunction with a meal that they've provided. That's another way that a widely attended event may present itself. Now, as Cynthia said, all of our pre-certifications are available on the website. When someone requests pre-certification, they send a letter that sets out the parameters for this event. You can access that too. So if you have not ever put on a widely attended event or you haven't participated in an educational function and you want to see how others have structured it and you want to see what we have approved and maybe questions we've asked or limitations we've given, you can see that yourself on the website. So it provides you, a form to go by, for lack of a better word, and gives you some guidance about how we've approached some of these issues before. So that's another way that our website can be helpful to you. Golfing and fishing. We've got advisory opinions that say that that can be an integral part of your event. I will just tell you that that is probably one of the quickest ways that you can get some criticism. It doesn't mean that it's illegal, but that's just what folks are writing about a lot, and that's kind of viewed publicly as a bit of an excessive, although legal at times, event that is allowed with some of these events. But from a PR standpoint, some folks have been written about because of that kind of hospitality that's been given as part of these events. I'll just put that warning out there to you that even if it's allowed, and it's a good example of even if it is technically allowed, you might want to exercise some judgment about whether it is something you should do if you're concerned about the impression that is being created. And of course, from our perspective, you should always be concerned about the impression and how others perceive your actions. If you have an amendment to who you were lobbying for, you've got 10 days to update that. So be sure to keep in contact with Vicki Manning if you've got amendments to make. And again, I cannot tell you enough, don't be afraid to call and say that you made a mistake on something that you filed or you need to correct something. That is what Vicki does all day long, and we really want you to comply with that. And then finally, and y'all are going to get out of here early. We've kind of gotten streamlined in the way we present these now. The legislature formed a commission to look at the ethics laws, and we are currently meeting and talking about all these issues that we talked about today, what you can give, what you can get, whether these limits are acceptable. And we will be making a recommendation to the legislature before the next general session about how we think the Ethics Act can be revised or strengthened, and how we can make it more reasonable in some application. Every one of these recommendations is coming from the practical application of this act, as you have seen through the enforcement actions that have been brought. So these enforcement actions have brought to light some features of the act that some consider to be unreasonable, and also from a prosecutor's standpoint, some problems in enforcement that have come to light too. So keep your eye out for what changes may come. If there are significant changes, you will be notified. If you were registered as a lobbyist, I mean, if there are substantial changes, then under the code, you might have to go through training again for that. As you know, you're one and done unless there's a substantial change to the act. And I would think that a massive rewrite of the Ethics Act would be considered a substantial change. So just stay aware of the fact that that's going on. Stay in contact with our office and just keep your eyes open. Do you have a question, sir?
I was just curious if the committee was just an independent committee or if it was something through ALI or how they formed the committee.
The question was whether the Revision Commission is an independent body or whether it is formed through ALI. The Alabama Law Institute. It is an independent commission that is set up. It is not an ALI revision. Now, there are 22 members represented here, And they're from the principal community, they're from the lobbyist community, they're from the enforcement community, and the State Bar also has representatives who are on there. Now, the American Law Institute has formed a group that is likewise looking at proposing a model rule, model set of rules for ethics to be adopted in the states. And this revision commission looked at their draft proposal, which is still very much a work in progress, when we started this work. And the Legislative Services Agency over at the legislature also did a 50-state study to highlight certain areas of the act and to show the Revision Commission how certain issues had been addressed nationally. What we have found is that our act looks remarkably similar to most of the acts that are out there. Okay, you're not hearing anything here today that is just some outlier in terms of what is allowed or prohibited. Where most of the change from state to state occurs is in the degree of what's allowed and what's disallowed. But pretty much we've got the same approach from state to state, and that point was very clear. There is also no real gold standard out there. I mean, everybody's kind of looking on this revision commission, at least early on, was kind of looking for the golden nugget out there that of one state that had done it perfectly, and that does not exist. But that's okay too. I mean, you know, one of the things I like about our act, and one thing I want to preserve is within our act, is the flexibility that our act provides. There's a temptation among a lot of people to want hard and fast answers to all these questions, which in my view would be a terrible thing because it would be completely inflexible and it just would not work. But having a fact-based analysis, which I'm confident we will retain, gives you the opportunity to customize this in ways that make sense and are reasonable and encourage good people to go into government and also to prevent corruption. And that's the balancing test that we're doing, which is a lot more than what you asked. But it is a process that can be messy at times, but it is being done by the people who are directly affected by this act. So as a lobbyist, you've got representatives who are very, very active in this, and I think that's a better method than having a group of lawyers who have never touched the act, simply looking at it from a statutory standpoint. But we have those people too, and we need their we need their input because we need the statute to read well. And so they're great participants too. I think it's a good group, and I think it's doing good work. I'm really encouraged by the progress. Any other questions from the hometown crowd? Yes, sir.
A little bit of an overview of the quarterly filing and the aspects of what we're completing each quarter.
Sure, I'm gonna let Vicki talk about that. If you could, just come up here and talk about kind of what that looks like on a quarterly basis. I mean, you can look in the statute and it'll tell you what you got to disclose. All right, and if you've got to disclose transactions with public officials, employees, or members of their household in excess of $250 in a 24-hour period, for example. So, if you have a pre-certified event and you spend $300 on somebody, you got to disclose that, even though it's pre-certified. Now, we don't have a lot of that, but we do have that from time to time. Or a transaction with a public official that's $500. Or in excess of $500. That's got to be disclosed as well. Now, within what I just told you, there are variations about, you know, what is the kind of transaction meant to be covered by that, and those are the kind of questions you can ask us through our opinion process. The question for those who are online is kind of what's got to be disclosed in your quarterly reports, and then there's some general information too. But Vicki, do you want to?
Well, what I was just going to mention, no, I don't want the mic.
Well, you got
what
that.
I was going to mention was about on your pre-certifications. If you send in a pre-certification, it's out online what you are spending on each person. When you file that quarterly report, let's make sure that pre-certification matches your quarterly report.
That's right. I mean, that's a good point. But that's also what generated the 2018-01 advisory opinion. Because the question that the BCA asked was about aggregating expenses. And how that came about is because everything is available to the public, you had interested citizens who were saying, hang on a minute, they had this event at X Hotel or X Resort, and I've looked in the rooms that alone are in excess of $250 a night. Why aren't they disclosing that? So that generated that opinion, and I'm not going to go into the mechanics of that opinion, but I think that it's fairly easy to follow. And it just simply says you have to accurately report. If you were spending $250 or in excess of that in a 24-hour period on whatever, you have to report it.
The cost. They're not. make sure they put the dollar amount.
Yeah.
They're not putting the dollar amount. They just put airfare. No, we want to know how much you spent on airfare.
That's right. We need you, what Vicky's saying is we need you to disclose the dollar amount of what you're doing, not just the fact that you did, because what's important is how much you did. Now, in certain circumstances, you can split that cost among a number of providers, but it's limited, but the opinion answers that. Is that what you were wanting to know? Okay. All right.
Quarterly reports have to be filed regardless of whether you did any lobbying or not.
Yeah, the quarterly report is required to be filed whether you actually did anything or not. As long as you're registered, you've got to file it. And look, and people look at that stuff. I mean, they really do. It kind of goes in waves, but people will look at it, and we'll go through periods of time where reporters are poring over those documents and they're trying to make connections, and they will look at the pre-certified events and they'll try to match it up. That's a valuable function of those. And in enforcement actions, they'll look at it. They'll want to see what you disclosed. That's why you've got to be honest. That's why we encourage you, if you did put something in there that was inaccurate, to amend, because you want it to be an accurate reflection of what you spent. And so do it before it's a problem. But go ahead and amend, and there's nothing, there's certainly nothing wrong with that. There was one other thing that I was going to point out to you. Make sure you review your quarterly reports yourself. If you've got somebody else who is filing it for you and it's going out over your name, you're responsible for whatever mistake is in there. And a lot of that goes on. We have people who don't review their own reports, and be in communication with your principal and make sure that they have, in fact, verified that you were their lobbyist, because that gums up the process when they don't do that. It's got to be affirmed on both ends that they have hired you and you are working for them. So again, contact Vicki. You can look online and see whether your information is on there. But you can call Vicki and you can say, "Has my principal, affirmed that I'm the lobbyist?" And she will say no. And in fact, they don't. They're very slow, but you can get up with them. And I'm not saying that to run people down. Y'all got plenty to do, and this is the least fun thing that you will engage in. So I mean, I get it, and I know that it can be monotonous to do it, but it's an easy way for you to get tripped up and for it to create a problem for you later when someone else discovers it that maybe you haven't registered. During the session, people will call over here and say, so-and-so's over at the State House, and I checked and they haven't registered. Why are they over here lobbying? More often than not, that may be because you have registered, but your principal hasn't confirmed that you, in fact, are their lobbyist. And so it may not be online just yet. But take care of that before the session. Make sure that all of that is sewed up before the session. So, any questions? Again, yes, sir. Hey, you can ask 100. I got nowhere to go. Fair enough.
Revolving door question, and I'm not foreseeing this happen. I'm just asking a question.
Right.
Differentiating lobbying and actual legal work. So if we had come from a government agency and it wasn't per se a lobbying situation, it may be an administrative hearing, a rule filing, or something like
Right.
that. Is that differentiated in statute, or are we going to do we need to let outside people do it?
Well, the question was revolving door. Let's say you were working for a public agency and then you went out into the private sector and you're handling something. The revolving door is going to apply to that, but it's going to say that you cannot represent your private sector employer back before your former government employer for a period of 2 years. Let's say you go with the firm. It doesn't mean that your firm can't do it. It just means that you yourself can't be the contact back before. So when you go into the private sector, that's really where the revolving door kicks in for the most part. We've recently issued a couple of advisory opinions that have recognized within the public sector itself that there is some allowance for representing your new public employer back before your former public employer. But once you choose to go into the private sector, then it's a different ball game altogether. So if you're leaving public and going into private, that's a great thing you can ask in an informal opinion. It's also the subject of a number of formal advisory opinions. And so keep that in mind, too. A formal advisory opinion is going to be the gold standard. It is going to give you the best protection. So if you're worried about it, ask for a formal advisory opinion. It doesn't have to be on an unanswered question. In most cases, it's not. In fact, they were designed to give you protection so that you could move freely, let's say, into the private sector and have some protection as it's allowed under the code for you to do certain things. So it might be something we've answered 100 times, but if it's important to you to have that protection, ask the question, and we give them.
No, I feel we can handle it without something. I just want to make sure
Yeah, I mean, and again, that's the revolving doors is remember, it's only limited to 2 years. 2 years can be a long time when you're sitting there waiting. I get it, but it's not forever. It's only for 2 years, and it doesn't disqualify everybody. It doesn't disqualify your business. It just applies to you. Yes. I don't. The question was, can you explain direct business association? If you want to explain that, as we have explained it in the opinions that we've given out, some of the informal guidance, feel free to do it. I think that it is best to handle that on a case-by-case basis. I think the definition is fairly clear for most circumstances, but if you have a question about whether you have a direct business relationship with somebody, that is a question I would recommend you ask in an informal opinion, and we can give you that answer. And that does come up from time to time. Do you want me to pass it to you?
I'll just, and the only thing I'm going to say about it is if you're a lobbyist for a board that contains public officials, you have a direct business association with that person, even though the entire board is who employs you. So that's the one circumstance where I know that this has come up. But yes, ask it on a case-by-case basis. If you question whether or not it's a direct business association, we will tell you. Because who you don't want to tell you whether or not it was a direct business association is a jury who has something to say about whether or not you reported properly. And I would say that in every one of these circumstances, people, because all we do all day long is talk about ethics and FCPA. And so you want us splitting the hair and answering the questions for you and giving opinions to you. You do not want 12 jurors splitting the hair over whether or not your relationship or your payment or what you provided to somebody is appropriate or not. So,
and I would add to that if for a question like a direct business association, it's one of those kind of things that if you think about it ahead of time, it can just save you a lot of headaches down the road, because somebody may think of it and they may know that there's some connection there and they may raise it. This is just an area where if you can cut down on the number of things that people can criticize you for or file something against you for by complying or over complying, it's just what I recommend that you do. So if you have a funky situation and they're out there about these associations, just ask us the question. And again, that's the value of the written informal opinion, is that you've got our answer and you've got our name at the bottom. You got my name at the bottom of it. You got Cynthia's name at the bottom of it. If we got it wrong, we got it wrong, but our name is at the bottom and we can't deny what we said. So we may have to eat crow. We may have to change that answer, but not in a way that would, that would affect you. But that's, that's what we got, and so we'll take that. So there is no reason not to ask the question. Because I'm sitting here for the 100th time telling you that we're happy to answer it for you. That's just what we do. And if it's the kind of thing that, don't feel shy about sending us an email at 11 o'clock at night. Oddly enough, sometimes we got nothing else to do and we'll answer those, or at least begin a dialogue about that. I'd rather go ahead and handle it at 11 than wait until the next morning knowing it's just sitting there in my inbox. So we're here and we're trying to be as accessible as we can, because we want you to do your job well, and we want to make it easy for you, cut down on the number of things you got to worry about, and also keep you out of trouble. But we're here to enforce if we have to. So I also want to stand in front of you and say that if we ever have to enforce it against you, I want it to be because I've given you every opportunity to comply and you just refused, because there's too many ways to stay out of trouble here. Any other questions before we get out of here? Yes, sir.
Is Vicki going to be available afterwards if we have some questions about our online filing?
Man, she sure is. Vicki will be available, and if you're viewing online, feel free to call. Now, we've got more people here today than we have in the past, so they may take up her time, but she'll get back to you. And if you can't get through to her, you can email me, or you can call me at the same number that was on the screen. That's my cell phone number, my official cell phone number here. You can write it down if you want to call me on that. If you ever have a question about how to submit a question to us in writing, feel free to use it. That's what that's there for too. So anything else? I'm going to wait just a few minutes and see if anything trickles in by text, but I haven't gotten anything. I will also tell you this, that the definition of lobbying, can be hard to apply in certain circumstances. Not every activity is covered by the definition of lobbying, so there's some exceptions there. If you've got people within your organization who are doing certain things that may not be advocating for the passage or defeat of legislation, for example, just know that there are some exceptions there to the definition of lobbying. Not everybody who shows up at the legislature is a lobbyist. I would tell you to apply that definition very liberally to your conduct. I think it's better to assume that you are a lobbyist than not. But if you've got a serious question about that, that's another thing that you can ask. Okay, so going once, going twice, going thrice. All right, we are done. So thanks for showing up. I think we're going to do another lobbying training for those online before the end of the year in December to catch everybody who has registered. There's an email. There's an email. We're going to have a kind of a catch-all before the start of the new year. So if there's anybody out there who is wanting to register, just know that we'll have another one too. All right, so thanks for attending, and if you have any questions, let us know.